Hello, everyone. I'm really excited to be with all of you again today. I've spoken on Yardi events before, and it's always a pleasure working with you guys. So let's go ahead and begin doing a legislative update today. We're going to start off with a federal update and then go into how NAA sees that affecting the state and local changes to laws that are happening around the country, and just talk a little bit about how we think this is going to affect your day-to-day now and moving forward. All right, so let's just start with the federal update. As you all know, the CDC stay of residential evictions has been in place since September of last year. With this most recent extension, you probably noticed there are three distinct modifications that were included in this last extension that goes through June 30th. First, covered persons may use any signed written form. They can submit any documentation as long as it has the required information to take advantage of the CDC protections. While that said, the CDC also released a new form as well as translations in commonly spoken languages, so that is available to residents as well. The second thing is that covered persons may not be evicted on the sole basis that they are alleged to have committed the crime of trespass. So they can't be evicted for that reason. I think this is part of the CDC's ongoing effort to prevent renter displacement and also to, unfortunately, further limit that sort of scope of evictions that can continue to take place through the moratorium. Along that same line, those who pose a health or safety risk or who have been or are being evicted for that reason, they should not be evicted if they claim exposure, if someone in their household has been exposed, or they say they've tested positive for COVID-19. So just be aware of a couple of those as continuing barriers as we try to navigate through the moratorium. I know that the CDC moratorium is being interpreted vastly differently across the country, but just some things to keep in mind through the end of this month. So you may have seen last month, this was really big news, that in federal DC District Court, that the Alabama and the Georgia Associations of Realtors, they sued HHS and CDC, and they won at the federal district court level. The Judge Friedrich, in that case, she did find that the CDC did exceed their authority in putting the moratorium into place. That exceeded their authority to protect public health, to regulate public health during an emergency, and she vacated the CDC order in its entirety. That would have had a nationwide effect, but the judge also at the same time granted the government's motion to stay her order, which prevents evictions from happening while the government's appeal is under consideration. So we're very closely monitoring this. I'm sure all of you are too. We expect an appeals court decision in June, but things are continuing to evolve this month. The latest that we've heard at the appeals court level is that the plaintiffs, the realtors, they did file a motion to remove that stay, and we're waiting to hear back if that was removed and that evictions that are covered under the CDC order, if those may continue or not. But as I said, things are still evolving, we'll see. I think for NAA's part, we are hopeful. We have seen a lot of really good case law come out of Tennessee, Texas, and now this DC case. But we're anxiously awaiting this decision, as are you, I'm sure, and we'll see. For this particular case, we do anticipate, from what we're hearing, that it may make its way to the Supreme Court, depending on how the appeals court will rule. But the realtors are already preparing to make sure that option is available to them, and that potentially that they could provide some sort of nationwide relief with this case. In addition to the CDC order, wanted to make sure that you knew a couple other things that are happening at the federal level. So as part of the administration's multi-agency effort to provide COVID-19 related housing support to folks, the CFPB and the FTC both came out and said they're stepping up enforcement efforts against housing providers who violate the CDC eviction order. And in their sort of expanded interpretation of consumer protection laws, the CDC came out with a rule to codify this, They are saying that debt collectors under the Fair Debt Collection Practices Act, they must provide written notification to tenants of their rights under the CDC order. And I'm sure you're thinking, well, how do I know if my tenant, if there are eligibility requirements there too, how do I know if it applies to them or not? I think they're sort of thinking in their eyes, since you don't know, that you're going to provide this notification to every resident before you move forward with an eviction. So wanted to make sure that we mention that, this is the CDC, the CFPB and the FTC are taking this very seriously. They've already sent out notification letters reminding management firms or owners of their responsibilities under the order. But remember that both agencies are pursuing these enforcement efforts, so just be aware. And it also hinges on that definition of debt collector. We know that attorneys fall under that definition of debt collector, certainly, but management companies who serve as agents collecting the debt on behalf of the owner, they may or may not, according to case law, also fall under that definition. So I think that for the lesson here is, and also one other thing to mention, we also know that in terms of evictions, there's a difference between cases that are just seeking possession of the unit, that the resident is judgment proof, they've skipped, and you're not seeking a money judgment, versus the cases where you are seeking a money judgment. And there is, you have to think through that as well in terms of if you're going to provide that, or if you think you need to provide that notification or not. Either way, I think this is just a good time with the new rule going into effect last month, just to check in with your attorney and see if you think this should apply. For our part, for NAA members, we did a couple things. For for Click and Lease users, we did send out a broadcast letting folks know that this is happening. And we did, put together some information on a form if that's something that you want to use through the Click and Lease program. And we also did a webinar. If that's of any interest to anyone, definitely let me know on this particular issue and other debt collection and consumer reporting issues that have come up during COVID-19, just to seek some information from our industry experts about where they come down on this. So as I said, just check in with your attorney if you think this applies to you. In terms of what's required, there is sample language in the CFPB rule. It's very brief. As a CYA, if you just want to put that into your notice, it's a pretty easy way to just provide that extra cover, even if you don't know whether it applies to you or not. Something we also wanted to make you aware of that's gaining more attention is that HUD is interpreting the CARES Act notice to vacate requirement, which requires housing providers to notify residents 30 days in advance, provide that 30-day notice to vacate notice prior to an eviction in cases of non-payment, if you remember the CARES Act moratorium. They are saying that even though the CARES Act moratorium has ended, that the notice to vacate requirement still is in effect today. And we just wanted to put this on your radar. Both the Office of Multifamily Housing Stakeholders for FHA properties and also the PIH office, which covers Section 8 properties and other federally assisted housing. This is something we just want to make sure we put on your radar. It's just another layer of federal requirements that are being asked of you, which I know is really frustrating to everyone, but we just want to make sure that you're aware of it. For our part, NAA is trying to make sure, as we have been throughout 2020 and 2021, to find a legislative solution and make sure that there is a clear sunset date in the CARES Act to put parameters around your liability for this particular provision, because we know that if it's not done right, or if it's being contested by the tenant's attorney in court, that can hamper any eviction proceedings that are happening for federally backed or federally assisted housing that the CARES Act did apply to. So I know we've been covering a lot on evictions, but I did want to mention a couple things on rental assistance. So you may or may not know that there is about $46 billion in federal rental assistance grant dollars that are moving through state and local rental assistance programs right now. The first round came out last year, and the U.S. Department of Treasury, who's the administrator for this money for the federal government, they released that money. That money was beginning to flow under ERA 1, is what they're calling it. And under ERA 2, most recently, they just released another round of funding, about $21.6 billion that is now moving under that banner through state and local programs as well. I'm making the distinction between ERA 1 and ERA 2 because, depending on how the state and local program handle it, they need to put certain parameters around those different pots of money. And unfortunately, this most recent pot of money comes with some restrictions that one that we were pleased to see, but a couple others that may or may not be frustrating to participating housing providers. Again, depending on how the state and local program implement those standards or requirements in their own programs. So a couple things happened. The Treasury said for ERA 2 in their guidance to state and local administrators of rental assistance programs that are handling federal money, they said that state and local programs cannot prevent renters or housing providers of subsidized housing from applying or receiving rental assistance. This had been a problem under ERA 1 and was frustrating for a lot of owners and residents in the affordable space. And so we were pleased to see that this clarification was put into new guidance just to make it clear that those federal dollars should be flowing to people who live in federally assisted housing for their portion of the rent. The three things that I did want to point out that you should certainly be aware of, one involving eviction. The second thing is program administrators may give payments, rental assistance payments, first and immediately to renters when housing providers refuse to participate. And with ERA 1, there was a requirement there that said that housing providers should be able to apply for rental assistance, and it should be given directly to housing providers. This is a bit of a setback, and we're interested to see how rental assistance programs handle it, but just as an FYI, those payments may go directly to the renter for them to use at their discretion if the housing provider refuses to participate. Third thing we wanted to make you aware of is program administrators are not required to prioritize arrears. And we are seeing, there's a group called the National State Housing Agencies. They are tracking a lot of what's going on with the state level programs, and they're finding a mix of how much money is being allocated or released in terms of arrears versus forward-facing payments. So just keep that in mind as well as you're deciding whether or not to participate and whether that fits for your business. The last thing we wanted to mention to you and wanted to highlight here is the guidance that the federal government put out for state and local programs to use. Is they said that housing providers must be prohibited from evicting residents for non-payment for the period where they are received as a condition to receiving payment, but for the period that the payment is for. They also left it up to the discretion of state and local program administrators to decide, you must prohibit them from evicting them for the period that the money covers, but you should also, in their minds, they have said that program administrators should also consider prohibiting the owner from evicting that resident for 30 to 90 days after that payment was supposed to cover their outstanding balance. So just keep that in mind as you're deciding whether to participate in programs or not. We know that our network of state and local affiliates around the country are working hard to make sure that these requirements are not a barrier to participating in programs and making them as efficient and effective as possible to help the owners and residents who are in need of rental assistance right now. But these are all just things you want to keep in mind. So in terms of our state and local outlook, where do we see things from going here? As you know and have seen and are feeling the pain of, eviction restrictions at the federal level, which normally would not be in place and is a process that's normally governed highly at the state and local level, is now being affected by federal legislation and regulation. And you've got some other requirements in terms of the consumer reporting restrictions that are happening under CARES and in other ways that are now affecting you as well. So how do we think that this is going to affect state and local legislation from here? So just looking at, as I had mentioned, all the stuff that we've seen coming down the pike from the federal level, we are certainly expecting that if the federal moratorium is struck down, since there's now, while there is case law on both sides, there are now some pretty strong cases that have affected whether the CDC moratorium is still effective in some parts of the country. That may affect whether the CDC decides to extend it moving forward. If you look at the CDC form that was released with this latest extension, you'll see that they preemptively dated that form to continue to be effective until September 30th, if that gives you any idea of where their mind is at in terms of wanting extensions. But with the growing case law against them, they may not be in a position to do that. We definitely expect that state and local governments are going to extend their own moratoriums past when the CDC moratorium expires in an effort to protect renters, especially at the local level. We're already seeing a movement towards that. And New York, for example, at the state level has already said that their eviction moratorium is extended, I believe, through August. So people are already preemptively taking that approach now. Keep in mind though, we have been working really hard at the federal level to make sure and to educate policymakers on the challenges to continuing this broad and sweeping emergency measure for more than a year now, what that does to the industry. And we want to make sure that that it is not extended again, and that the focus now is on rental assistance, emergency rental assistance, and targeted assistance for those who need it, making Section 8 and other programs more robust to handle the caseload for those who may need more long-term housing support. We need to take the focus off the federal eviction moratorium. Wanted to let you know though that the enhanced unemployment benefits and some of the other financial benefits that renters may be benefiting from or may be seeing, those are set to expire in the next couple months. So that will certainly affect whether state and local governments decide to extend their eviction moratoriums or not, past what the federal government does. We're also anticipating, and it's already happening now, that you'll likely see legislation that makes it more difficult to evict. In light of the eviction lab, that research happening, that's been happening for the last several years in light of the book Evicted, as well as additional research that's been happening around COVID to justify the federal moratorium that says that is keeping COVID-19 cases down. You're likely to see these pieces of research affect other legislation other than moratoria, in terms of putting into place just cause eviction. If some of you are familiar with that, it lists specific reasons in the law as to which highly limit how and for what reasons you can evict. It also kind of takes things out of your hands in being able to put out non-renewal notices as well. We are also anticipating, as you can imagine, that COVID-19 hardship is going to be an affirmative defense in eviction cases, or there's going to be a movement to do that to add protections for renters. And I think one of the biggest things we're seeing that are going to hit you as well is the idea that owners should be punished or deterred from filing for eviction. So some places, especially at the local level, are looking at really exorbitant increases to filing fees as a way to cut down on evictions, because they don't necessarily have the money for enhancing rental assistance coming from the federal government, or to bolster those housing support programs. They're looking at other ways, unfortunately, that affect owners and operators to protect renters. Another movement that I'm sure you've all seen, and Washington State has certainly, and New York City have certainly led the way in terms of making tenant representation in eviction court a requirement. Washington State just did this for indigent tenants, and we will likely see a movement not just for right to counsel, but for bolstering funds for legal assistance for renters in eviction court. As you all know, that in civil cases, that's not guaranteed, in comparison to criminal cases. Two other things that we wanted to put on your radar as well are we definitely expect that to preserve housing access and opportunity in high opportunity areas for renters who've been affected by COVID or who have been made vulnerable by their eviction history or their criminal history, their financial history, where we definitely expect a greater interest in increasing fair housing protections for ex-offenders, for COVID-19 evictions. That's how they're sort of putting parameters around it. So any evictions that happened in the last year, you would no longer be able to evaluate in the eviction process. We've seen a movement there as well. So just expect some of these sorts of things to happen. I know that we're working really hard in our advocacy to make sure that these aren't included at the federal level and the FCRA and in other areas, and state and local affiliates are doing their part as well. But you can expect some of these changes, these really difficult movements to happen right now in the current circumstances. It's hard to push back against this heavy moving train. The fourth thing we wanted to make sure is on your radar as well is not just in terms of protecting vulnerable renters who've been affected by COVID, or like I said, been financially disadvantaged in some way. You're likely to see more interest in renters' choice legislation. And if any of you aren't familiar with that, renters' choice legislation is basically enabling legislation that allows security deposit insurance or other security deposit alternatives to flourish in the market, to be used in the market. So we have seen in some cases like Cincinnati that this type of legislation will say you can, whatever your normal security deposit restriction is in your state or locality, if it's 1 month or 2 months rent, if you want to charge the full amount, you can only do that in equal payments over 3 months. You can no longer charge that up front, or you have to allow the resident to use some sort of security deposit alternative. And that's something that we've been looking at as well, because we know that in terms of tenants' rights advocates, they've long seen these large upfront costs of first and last month's rent and fees and other things that you need to be able to move into new housing. They've long seen those as barriers, again, to access and opportunity to housing. So we're expecting that this type of legislation is going to continue to be of strong interest to policymakers in the near future as well. So how can you keep up with NAA? I know I've went over a lot today, and this is just a taste of everything that we're normally tracking and actively pursuing or monitoring at the federal level and working with our state and local affiliates on the state and local level. Well, first, you can keep up with NAA's advocacy and learn more about our position on issues in the policy issue section under number 1. We've also just recently updated our tracking map, which looks at all of the federal legislation that we're tracking, that we're looking at moving through Congress. And we look at statewide trends as well. What's, like I talked about, right to counsel, changes to eviction laws, rent control, some of these other big issues that pop up perennially. And the newer issues like renters' choice, we're tracking that as well. So you can understand where we're seeing that around the country and understand what's coming down the pike for you. That's in number 2. Number 3 is, I would say the most important, is we hope that you will continue to take action, and thank you to the thousands of you who already have. Whenever you see an alert going out from Bob Pinniger, from our CEO, to contact your member of Congress and let them know, one of the alerts that we have out right now is to let them know how the eviction moratorium is affecting you. We are pounding the pavement, so to speak, every day, talking to members of Congress, helping them understand the industry and the potential unintended consequences that certain legislation will have. But nothing beats hearing from your constituents and sharing your story with your member of Congress. That hits closer to home, that resonates in their mind whenever they see new legislation come up. And that is probably, certainly second to your everyday job, one of the most important things you can do to protect the rental housing industry and your business. So that is all I had for you today. I know I kind of flooded you with a lot of information, but I hope it was helpful. I think from here, if you want to put your questions into the live chat, please do so, or please feel free at any time to contact me. I put my email address here, and of course, we're always happy to help. Thanks again for tuning in.